let me ask you this question. What's the difference between a legitimate direct sales opportunity and a pyramid scheme?
Okay, that's a great question. It's a great question, and it is one that has been a bit perplexing because they both look alike. They both have a pyramid aspect to it, as all business has a pyramid aspect to it. The differentiating feature, however, we always like to say, and when I'm in court or I'm explaining to the press or I'm explaining to companies that may be suppliers, the question is always, what is it that people are paying and why are they paying it? If you're selling a product or a service and it stands on its own in the marketplace, people would buy it because they want it. Then you have a real legitimate direct selling company. If on the other hand, basically people, the quality of the product is low, the price is high, it merely becomes an excuse for people to basically buy the product because they want to qualify in the program to recruit others and make money and make commissions. If you'll indulge me for a second, I'll give you a bit of a metaphor that I think would allow you and allow viewers to think about the essential difference. There's a story about a gentleman, we'll call him party number 1, and he sells a case of cans of tuna fish to party number 2 for $10. And party number 2 sells it to number 3 for $20. And number 3 continues until number 10 buys that case of cans of tuna fish for $500. And he opens it up, and he opens the tuna, and it's rancid. It's inedible. And he goes back to number 9, and he says, I bought for $500, I bought this case of tuna. And he complains, and number 9 says, well, you ought to go back to number 8, and so on until number 10 goes all the way back to number 1 and says, you're the one that started all of this. He says, I have a problem. And number 1 says, well, what's your problem? And number 10 says, well, I bought this tuna fish, I opened it up, it's rancid, it's no good. Number 1 says, well, what's your problem? Number 10 says, don't you understand? It's rancid. How am I going to sell this? And number 1 says, well, you don't have a problem. And number 10 says, what do you mean I don't have a problem? And number 1 says, you don't understand. This tuna is for selling. It's not for eating.
Right.
If you think about that, that metaphor may explain the difference between something that's legit and not.
It was never meant to be consumed.
That's right.
It was always meant to be merely a product that got sold and resold and resold.
And sometimes in the original cases, the original pyramid scheme cases, it was just about money. The original pyramid scheme case started before we had pyramid laws. And that was the gentleman who was very charismatic, named Glenn Turner, had a program called Dare to Be Great. It was a motivational seminar, and people would basically be invited to come to the seminar, pay $5,000, where they would be taught how to go out and get someone else to come to the seminar, where they would pay $5,000 and so on. We didn't have pyramid laws. This was in the late 1960s. And he was prosecuted under securities laws, and it was put out of business as an illegal pyramid scheme, because a pyramid also is a security. It's a passive investment that will not stand up. And as a result, almost all states adopted pyramid laws, which basically said it's illegal to make people have to pay money for the right to go recruit others. Just effectively who will do the same and so on.
They call that a paid to play, right?
It's a pay to play, and that's why every statute that's a pyramid statute has what is referenced as a prohibited investment, meaning other than the exemption for purchasing an at-cost sales kit, typically $49 up to $100, which is sold not for profit, no commissions paid, very well accepted. Every leading company has this. All other purchases from the company are optional, and the key issue is whether or not people buy the product because they want to use it for their own purpose or they want to sell it. So, Chris, there was a recent situation that is perhaps the most recent situation in which our Federal Trade Commission accused a company of being a pyramid scheme, not a legitimate direct selling company. It had the elements. It looked on its face and its purpose as is if it was legitimate. But the Federal Trade Commission accused it of being a pyramid, and a federal court agreed. The company was called Burn Lounge, and the company basically intended to make a market in selling music online. Probably not unlike we get from iTunes or anywhere else.
Yeah.
And it tended to offer that through independent distributors, consultants, marketers. And it offered marketers the opportunity to basically buy at various packages, website hosting packages, where they could drive customers to their websites, and they could, where people could download music and they could make some money.
Got it.
And that's how it looked on its face. And these packages went up to several $100s. Now the problem is those packages were really regarded by the court and by the FTC as tools, not as products.
Oh, I understand.
But in fact, Burn Lounge paid commissions on all of those purchases of those website packages.
Got it.
In fact, what the court found, as a matter of fact, was that there were approximately $29 million. There was approximately $29 million in sales done by Burn Lounge, of which only $1 million was downloaded music.
Right.
So 1 million out of 29 million. The rest was basically from the sale of the packages to the distributors. And the court basically concluded, we think we know what is happening. We think distributors are encouraged to buy these packages, find other distributors to buy the packages, make a lot of money, and that's where the commissions were coming from. And in the end, the FTC and the court basically said, you know what? The sale of music was really incidental. It was an excuse. Really what was happening here was this was a movement of money. And we've seen this happen many times in the industry, and it's only a matter of common sense. Again, what is it that people are paying, and why are they paying for it? And it's one of those situations where the court in the Burn Lounge case actually indicated if they were buying music and other things for their own use, not tools, the court would recognize the concept that we've often seen in the industry called personal use, which has been a bit controversial from time to time. And we've even seen it recently in some questions posed in our stock market. However, the court seemed to think that the personal use would be fine if people were using the music or the product. However, unfortunately, the FTC, as it is wont to do in its final order, got an order that basically indicated that even purchases for personal use should not be considered in terms of a legitimate MLM. It was inconsistent with its own previous position, inconsistent with some of the court's own statements, and it will pose some problems in the future. But getting back to the issue of what's real and what's not, it really is common sense. It's common sense, and that is, does something stand on its own? I often like to tell people, here's how you know if you're involved in something real. If you can go to your next door neighbor and you can basically look him in the eye and say, I have a great product for you, I have a great opportunity for you, and feel like you're doing him a favor, you're doing great. On the other hand, if you go next door to your neighbor and you're looking down at your shoes the entire time you're telling him about this great product and opportunity, maybe you're in the wrong thing.
Got it.
You've got to be proud of what you are marketing. You have to be bonded with the product and the company, and it really is common sense.
Awesome. I appreciate that. Thank you.